Jurisdiction in civil and commercial matters. The Brussels I and Brussels I recast regulations. General introduction. Jurisdiction of the courts of the member states and rules of applicable law in civil and commercial matters are at the heart of judicial cooperation in civil matters in the European Union. National rules of private international law and international civil procedures differ from state to state. This can hamper the sound operation of the internal market in the European Union. To prevent this, it is essential that there be uniform provisions in the EU which determine the competent court as well as simplified procedural formalities to achieve rapid and simple recognition and enforcement of judicial decisions issued in another member state. This way, it is ensured that judicial decisions can circulate freely from one member state to another. In that respect, the Brussels I regulation and then its revised version, the Brussels I recast regulation, were enacted. The scope of the Brussels I and Brussels I recast regulations. The regulation applies in civil and commercial matters, excluding revenue, customs, or administrative matters. It does not apply to certain areas of civil law, such as the status or legal capacity of natural persons, matrimonial matters, wills, and succession or bankruptcy. Nor does it apply in relation to matters of maintenance, other than for transitional cases, unlike the original version of Brussels I, since maintenance is now dealt with by the regulation on that specific subject. The jurisdictional system of the Brussels I and Brussels I recast regulations. Brussels I sets out a closed jurisdictional system, assigning jurisdictional competence as between courts of the member states to resolve cross-border civil and commercial disputes. The competent court within the judicial system of the member state, with jurisdiction under the regulation, is then designated by the domestic rules of civil procedure of the member state concerned. Only the jurisdiction rules in Brussels I can apply as between the EU member states, and certain of the jurisdiction rules of the national law of the member states are not to be applied as against persons domiciled in a member state, though they are still available against non-EU domiciliaries. The basic rule: jurisdiction of the defendant's domicile. The basic jurisdiction rule, according to Article 4 of Brussels I, is that for persons domiciled in the territory of a member state, jurisdiction is exercised by the courts of the member state in which the defendant is domiciled, regardless of his or her nationality. Domicile is determined in accordance with the domestic law of the member state where the court has been seized. In the case of legal persons or firms, their domicile is determined by the country where they have their statutory seat, central administration, or principal place of business. If the defendant is not domiciled in a member state, Article 6 of the regulation states that the jurisdiction of the courts of each member state will be determined by national law, subject to the protective jurisdiction rules for consumers in Article 18 and employees in Article 21, and the rules for exclusive jurisdiction and prorogation of jurisdiction in Articles 24 and 25, respectively. Alternative and special rules of jurisdiction. Articles 7 to 9 of the regulation contain rules of special jurisdiction alternative to the general rule in Article 4. Some of these rules enable the plaintiff to choose whether to commence proceedings in the courts of the member state of the defendant's domicile or in courts of another member state having a special jurisdictional basis. In practice, the most important special jurisdiction is contained in Article 7.1, which involves matters relating to contract, other than contracts of employment or insurance, or with consumers. International jurisdiction over the cause of action lies with the courts of the place of performance of the obligation in question under the contract. In the case of the two contract types found most frequently in European cross-border practice, the place of performance covers all obligations arising out of the same contract. Unless otherwise agreed, in the case of the sale of goods, The place of performance of the obligation is the place in a member state where, under the contract, the goods were delivered or should have been delivered, and in the case of the provision of services, the place where, under the contract, the services were provided or should have been provided. Article 7 provides further special rules of jurisdiction over several special matters, like, for example, matters relating to civil claims for damages or restitution, or as regards disputes arising out of the operations of a branch, agency, or other establishment. Article 7(2), which covers jurisdiction over matters relating to delict and tort, has assumed increasing importance. Claims in matters relating to tort, delict, or quasi-delict may be raised in the courts of the place where the harmful event occurred or may occur. The European Court of Justice has established that this is the place where the damage occurs, or, alternatively, the place where the damaging action was carried out or produced. Measures for interim relief and provisional protection. With regard to provisional measures, Article 35 of Brussels I also provides for an application to be made to the courts of a member state, when such measures are available under the law of that state. This applies even if the courts of another member state have jurisdiction as to the substance of the matter. It should be noted that in the recast of Brussels I, there is a new definition of judgment whereby the term is extended to include a judgment granting a provisional or protective measure by a court with jurisdiction under the regulation on the substance. This does not include such a measure granted by such a court without the defender, presumably the person against whom the measure is granted, being summoned to appear before the measure is granted, unless the judgment containing the measure is served on the defender before enforcement takes place. However, a judgment granting a provisional and protective measure issued by a court which does not have jurisdiction on the substance under Brussels I is not recognized and enforced under the regulation.